I just wanted to mention one other broad point, before Your Lordships will allow me to respond to Your Lordship's query a little later, if Your Lordships permit me to do that. I just wanted to make one other broad point, So, either way, if both of them are absent or for some reason cannot participate, somebody else will be appointed. Right? Now, in this context, look at paragraph 6.2 of the 10th schedule. They have to be read together. It's just another broad point I wanted to make before Your Lordships. So what is it that I am canvassing before Your Lordships? That there can be no hiatus. Yes. If there's a deputy speaker against you who have given notice, the disqualification proceedings don't stop. That's my first, at the outset I made that submission to Your Lordship. And they've not answered it. That's why the order of this court on the 27th, saying that, all right, you can file your reply, is as the proceedings won't go on. Is as if their proceedings won't go on. Because somebody else would have presided over the House and proceeded with the disqualification. This is the problem with the Nabam Rebia judgment now.
So it gets referred.
And the deputy speaker cannot decide.
Until the decision of the committee of the House is taken, what happens in the interregnum?
Which decision of which committee?
This question as to his disqualification is referred to the committee.
Yes.
Right? Committee is looking into the matter. In the meanwhile, what happens?
No, the person elected as the speaker then, or chairing the House, will decide. There is no committee.
Read with 180.
Yes. There is no committee. So, therefore, all this not dealt with in Nabam Rebia.
What's the ground for removal of this?
That's the other point I wanted. No ground. I'll show Your Lordship that notice. Nothing.
So that was not a disqualification. He was not being removed under
disqualification
under the 10th schedule.
Correct. Therefore, that notice was an ab initio void.
No, but they can always say that we don't have confidence in the speaker.
No, they can't, because that's the removal proceedings are under 179. I showed Your Lordship Shakhtar and Kaul, which says it has to be for reason. I showed that Your Lordships at the outset. Because removal is stigma, which is why he is allowed to be in the House, allowed to participate in the proceedings and respond to the allegations. It's not a no confidence. No confidence is no reasons. It's a removal. Again, not considered in Nabam. So these are very serious questions. That's another broad point I wanted to make, before I proceed.
Yes.
That's the heart of the decision. It's not that he cannot call for a floor test. But the reasons on the basis of which he must call for a floor test must not be extraneous and irrelevant, which is what I tried to show yesterday to Your Lordships. That's the heart of the matter. That's the decision of the governor. The 34 of them have come to me and I recognize them. If that's germane to his decision-making, constitutionally germane to his decision-making process, he's right. And that's why I said to Your Lordships yesterday, and I gave Your Lordships the Sarkaria Commission, that the governor can only deal with alliances. He can only deal with parties. He cannot deal with individuals. Otherwise, there'll be havoc. Any 3 people from any party will go to say that now you must call for a floor test. 8 out of 32 members were ministers of the government. The rest were not ministers. So how could he say they want to move out of government? Only 8 of them. So on what constitutional basis can the governor recognize, whether minority or majority, a faction in the legislative party to direct a floor test? My Lord asked me a question related to this. Paragraph 3 said not less than 1/3. It could be 75%. So it envisaged a situation where the majority would go away, a minimum being 1/3, and gave that protection. After it was deleted, neither 1/3 nor 75 will get protection. That's the consequence. And if Your Lordships reads paragraph 3 with me for a minute, it's very interesting. So what's one thing is quite clear, that the paragraph 3 dealt with factions. An argument to say that I am the party is contrary to the constitutional framework, because he is not the party. Because the party is registered under section 29A of the Representation of Peoples Act. The office bearers of the party are communicated to the Election Commission. And the Constitution as accepted is the final document. He can't now say, I am the party, because the party with the election commission and the party with the speaker is only the members of the legislature belonging to that political party. So you can't say I'm the party. So that proposition is unfounded in constitutional law. And Malas, your lordships have now read all the documents. Till July the 4th, is there any reference to any split? No reference. No mention of split. With the deletion of paragraph 3 of the 10th schedule by the Constitution 91st Amendment, there is no constitutional recognition of a faction or group in the legislature party. Reference is invited to petitioners' written submissions 160 to 163. Malas, your lordship have it. I've given the page so that it's easy, Malas. The effect of deletion of paragraph 3 from the 10th schedule is that the Constitution does not recognize any faction, whether it consists of majority or a minority of the members of the legislature party. Why? Malas, there's a constitutional basis for that also. I tell you just why. Malas, when I seek election directly from the electorate, I don't seek election in my personal capacity. I seek election on the symbol of the party. In my activity in the house and outside the house, I continue to be a member of that party and must honor the discipline that's imposed on me. So in the relationship between the legislature and the political party has primacy. The legislature party has not primacy. So when you are interpreting the Constitution, you have to give primacy to that political party whose representative I am in the legislature. You can't in the process give primacy to the legislature over the political party, which the other side is trying to do. By saying, I am the party. It can be one member of legislature, but can he say, I am the party? So within the constitutional framework, the will of the legislators, in fact, is subject to the functioning of the political party both inside and outside the house. Now he can have dissent outside the house, but no dissent within the house, which is why the whip. Because there he represents. That's why Holohon says you can't go against it. That's the rationale for it, Malats, constitutional rationale for it. Then Malats, a fortiori, therefore the concept of a faction asserting itself in the legislative party and acting dehors the political party or calling itself the political party is not contemplated by the law, and any such claim will be per se fall foul of paragraph 2 of the 10th schedule. Parliamentary democracy only recognizes alliances between political parties and not an alliance between a political party and a faction of a legislature party. That be constitutional harakiri, Malats. There is no space for factions when the governor, Malats, has to appoint a chief minister. Now, Malats, if all of Shiv Sena had gone to the BJP, governor will call for a floor test. If the Shiv Sena itself had gone. Now, Malats, this is cast in stone. Now an argument is being raised, it doesn't matter, and which is why, Malad, I said to your lordship the consequences of it. Malad, supposing 2 or 3 members of each political party who don't form the majority go to the governor and say that support of 6 of these people reduces the chief minister to a minority, therefore call for a floor test. Malad, it would be disastrous for democracy. That's the Ayaram Gayaram principle that we gave up. Would 50 members of BJP today, Malad, support Uddhav Thackeray, will he call for a test? So, the whole propositions, the propositions that have been advanced by my learned friends are all contrary to basic principles of constitutional law. So, the primacy is of the party. The legislature has no identity other than being a representative of the party.
That's okay. I think, you've paraphrased it and there is no reason to doubt it.
Right. The reason is, what he sends is that he has been elected as is sponsored by the political party and he has been duly elected. And the certificate also says the same thing. Then, Malats, item 9, corresponding rules of the conduct of election rules are Rule 64, 66, which prescribes 21C, Form 22 to be referred to by the returning officer. 21C deals with the format of declaration of the result of elections by the returning officer, and it explicitly requires the name of the recognized registered political party that has sponsored the candidate to be recorded. The same details are also required to be recorded in Form 22, which concerns the certificate election provided. Therefore, it is respectfully submitted that an elected member of the Legislative Assembly does not have any independent identity in the House except as a member of the political party to which he belongs. Accordingly, the governor could not have recognized any members of the legislature party, dehorsed their political party, and permitted them to make a representation against the government formed by the political party to which they belonged. So, Malas, he should have assumed that they continued to be in the Shiv Sena, and that Shiv Sena had 52 members, and all the three parties together have 152 out of a house of 280. There was no occasion for him to say, have a floor test. And undisputedly, in the present case, the group of the Shiv Sena legislature party, represented by Eknath Shinde, is a faction of the legislature party, albeit a majority. The recognition of a majority of Shiv Sena MLAs by the governor to entertain a doubt about the confidence enjoyed by the government is in the teeth of the provisions of the 10th schedule and of the constitutional scheme related to election of members to the Legislative Assembly. Therefore, governor could not have asked the government headed by Uddhav Thackeray to seek a trust vote on the floor of the House on the 30th of June. On this basis, the governor's decision rather placed a premium on the unconstitutional acts of a faction in the legislature party, allowing them to topple an elected government. He knows, because he is not a member of the assembly, but he is part of the legislature. So he knows. So he went outside the scheme of the 10th schedule as well as the scheme of the constitution to recognize a faction. Majority or minority doesn't matter. The governor is knowing fully well that a faction of the legislature party cannot be recognized under the Constitution.
Sorry, just to pause here. According to you, suppose there is a split, which is now, of course, not recognized.
Yes.
So, what would have been a split under the unamended provisions of of the 10th schedule? But there is a group of legislators who would otherwise, who have otherwise left they say we have withdrawn support.
Correct.
Right, whether they withdrew support here or not, that you already made your point.